Hi, folks. I'm Greg McLawsen. I'm the Affidavit of Support lawyer. I represent green card holders in federal lawsuits to enforce the Affidavit of Support, and I serve as a consulting expert in family law cases when green card holders enforce the Affidavit of Support in the context of a divorce case. Today, we're going to talk about California. California is one of the states that has seen the most litigation around the Affidavit of Support. We've done cases in the Central District in Los Angeles and Southern District, all over the place in the state. I would say California is right up there with Texas and North Carolina, oddly, in terms of states that have seen the most enforcement of the Affidavit of Support. California is probably, if I had to say, the place where green card holders have the most and the best strategic options available to them when it comes to enforcing the Affidavit of Support. So let's talk about family law litigation first. So the Affidavit of Support is signed in all family-sponsored immigration cases with very few exceptions. But most of the litigation that we see comes out of one spouse versus another spouse. So we're talking about where a US citizen or occasionally a US resident, usually it's a citizen, has sponsored the immigration of a foreign national. And that foreign national often either during or following a divorce needs to enforce their right to financial support from the US citizen. So it's often when a divorce is going on that a green card holder comes to realize that they have rights under the affidavit and starts looking into options to enforce it. Well, California is one of the states, along with Texas and again North Carolina, that has really clear case law when it comes to whether a green card holder can enforce the affidavit in a family law case. In the Marriage of Kumar case, which arose, I believe it was the 4th Appellate District in California, the one that has jurisdiction over the Bay Area. In the Kumar case, that clearly addressed the issue and said, yes, a green card holder can use a family court proceeding to enforce the Affidavit of Support and can use spousal maintenance or alimony. I'm using both terms because different states use either one, can use spousal maintenance as a vehicle to enforce the affidavit. So that is by contrast to states like my home state of Washington, which under the matter of con case says, no, you can't use maintenance as a way to enforce the affidavit. The rights in the affidavit are in the nature of contract claims and can't be shoehorned into a maintenance award. California is different. California says, yes, a foreign national can use maintenance as a way to enforce the rights under the affidavit. Now, that's great news for a green card holder who is already going through a divorce proceeding, because that person doesn't have to think about filing a separate civil action to enforce the affidavit. Instead, if they do it effectively, they can use the existing family court proceedings as a way to enforce the Affidavit of Support. So that's really good news for green card holders. It gives them a nice, effective, and efficient way to enforce the affidavit. Now, I will say that one of the things that we see occur in family law proceedings is that the assertion of the I-864 rights gets muddied by factors under family law. So when it comes to the affidavit itself, and if you look at the provisions of the Immigration and Nationality Act that underlie it, it's very clear in terms of what the financial obligation of a sponsor is. That is to ensure financial support of the immigrant at 125% of the poverty guideline. And it's also clear how long that obligation lasts. It goes on until the 5 terminating events that are defined by federal law. Those are most notably when the foreign national either naturalizes or has 40 quarters of work. So in those terms, it's clear how long the obligation lasts. What we see happen sometimes in family proceedings is that applying considerations that are appropriate under family law, a court will limit the duration of support that's ordered under the affidavit. So a judge might say, okay, I understand that the affidavit of support is enforceable, and yes, I can read what the 5 terminating events are. But considering this as a matter of family law, I'm going to limit the duration of support awarded to 1 year or 2 years. Now, that's a mistake, and typically we will see that sort of a decision get overturned on appeal. But that's not an ideal outcome. You don't want to have to take your case up on appeal to successfully assert your rights. I think what that is a result of sometimes is not great advocacy at the trial level. So I'm not trying to cast aspersions on other members of the bar, but I believe probably sometimes the judges aren't getting adequate briefing about the affidavit of support. So this is just to say that I think with good attorneys representing the green card holder, you should be able to get an award in California that isn't artificially limited in the way that we have seen both in California and other states. Most recently, this happened in Ohio, where a judge in a family proceeding didn't adequately enforce the affidavit and got overturned on appeal. So option number 1 is for somebody who's already in divorce proceedings in California. Yes, you should be able to go into family law court and effectively enforce the affidavit of support through a spousal maintenance order. That's something that I help with. I serve as a consulting expert in those family court proceedings because often the poor family law attorney who's had this thing come up will never have seen the affidavit of support in their life. And why would they have? It's a relatively specialized aspect of U.S. immigration law. With that being said, the Marriage of Kumar case has been around for several years now, and the California bar should be getting up to speed on the fact that this is something that does occur in family law proceedings and can be enforced there. So read the Marriage of Kumar case if you are a family court attorney in California. So option number 1, go to family court. Option 2, which is a very strong option also, is that green card holders can and most certainly do enforce the affidavit of support in federal court. Now, federal court doesn't typically have jurisdiction over contractual disputes. What makes this different is that the affidavit of support isn't just any old contract. It's created by a provision of the Immigration and Nationality Act. So 8 U.S.C. 1183A is the entire section of the Immigration and Nationality Act devoted to the affidavit of support. And in subsection E1 of that provision in the INA, it specifically gives sponsored green card holders what's called a private right of action to enforce the affidavit of support. So the contract is between the U.S. sponsor and the government, and usually only parties to a contract can enforce it. But the INA, Immigration and Nationality Act, specifically says that a sponsored immigrant can enforce their rights in federal court. And this has been done numerous times in California, and there have been over 150 cases nationwide in federal court. A couple notable things about I-864 litigation in California. First of all, it's well established under the Erler case, which is out of the Ninth Circuit Court of Appeals, which has jurisdiction over California, that yes, a green card holder can enforce her right to support. So there's no question about that under the Erler decision. But then we also have district level decisions within California that stand for the proposition that I-864 sponsors can't avoid liability on the basis of contract law defenses. So under common law governing contract, both in California and in other states, there are all sorts of different ways that a party to a contract can potentially avoid liability. The one that we see raised the most often, unsuccessfully, but nonetheless raised, is that the sponsor was duped into marriage. So the sponsors want to raise a defense of fraud and say that The foreign national married them only for a green card. It was never a real marriage, and they were duped into it. And for that reason, the I-864 that they signed as part of the process was procured by fraud and is therefore void. I will say that even in other federal courts that have allowed that defense to proceed, sponsors nonetheless lose on it, because the mere fact that a marriage subsequently falls apart doesn't mean that the whole thing was a fraud. It just means the marriage didn't work out. But federal courts in California go one step further. The federal courts in California say that those contract defenses categorically do not apply in I-864 litigation. So federal judges in California look at the statute and they say, well, this statute gives 5 terminating events that end the sponsor's obligation. It's actually 2 in the contract, 2 in the statute, and 3 more are added by implementing regulations in 8 CFR Part 213A. But at any rate, they're under federal law. The judges say, look, there are these 5 terminating events under federal law. Those are the only ways that a sponsor can get out from under the obligation of the I-864. And there is nothing in federal law that allows a sponsor to get out of this through allegations of fraud or any other type of defense that might normally apply in contract litigation. So again, usually these defenses like fraud are just baloney to begin with. But what they do is, if those defenses are allowed to move forward, they make the case a lot more complicated than it needs to be. And suddenly the parties have to get into discovery about, did she or didn't she love him, and all of this collateral stuff. But not in California. So in California, it is very clear that the focus in these matters is narrow. And the legal issues that are really at stake are, did the sponsor sign the affidavit? Well, that's not in contention usually. We can get a copy of it through the Freedom of Information Act. Did the green card holder become a green card holder? Yeah, she did. That's why she's holding the green card that specifies that she got status as the spouse of a U.S. citizen. The only other question in the case is, what is that person's income? Because damages in the case are determined by the difference between her income and 125% of the federal poverty guideline. So that makes it a relatively focused type of litigation. And there is nothing that the defendant sponsor can do to defend the litigation except to show that one of those terminating events has happened. And that's not going to be a big mystery. Did the green card holder become a citizen? No, she didn't. You can prove that. Does she have 40 quarters of work? Well, if she's been here for 3 years, it's not conceivable that she has 10 years of work history. So although family law court is, in one sense, a great and very efficient option for folks in California, on the other hand, you also have very strong legal precedent within California and the Ninth Circuit that makes federal court also a really good option. One additional consideration that perhaps leans in favor of federal court is that attorney fees under the Affidavit of Support are recoverable from the sponsor. So yeah, on the one hand, it seems expensive to have an additional piece of litigation. If you're already in divorce court, why not handle it there? On the other hand, if you have to go to federal court to enforce the affidavit, it's the sponsor who pays for that under 8 U.S.C. 1183A sub C. So as the beneficiary of an affidavit of support, the person really has all those options available to them. And that's a great position to be in. Again, folks in California really are as well situated as anyone anywhere in the country when it comes to good options to enforce the affidavit of support. If you have questions about these cases in California, feel free to drop them into comments. If there are individualized, fact-specific questions, you're welcome to reach out to me on the website, We're happy to offer free consultations. We have co-counsel in California that represents California-based clients with us, and we're happy to talk to you about the facts of your case if you're based in California. Hope that's helpful. Everyone have a great week and take care.